Good evening, and thank you for joining us for this virtual rally. My name is Ryan Burrows, Executive Director of the American Kratom Association. We scheduled this rally ahead of a critical hearing tomorrow in Ohio on the Kratom Consumer Protection Act, and we have received word of the Florida Department of Agriculture quarantining kratom products and fining business owners. The Q&A is open, and we are joined this evening by Mac Haddo, Senior Fellow on Public Policy, to get into the details on these issues and discuss these matters in further detail.
So thank you, Ryan, and thanks to everyone who's joining us this evening. Let me tell you first what I think is really great news for the kratom community that is evidenced by some of the meetings that I've been able to participate in that speak to the growing acceptance of kratom on the international stage. There was a seminar convened in the Czech Republic a couple of months ago. And the subject of that and the reason why that conference was held is that the Minister of Health in the Czech Republic was parroting what the FDA here in the United States has been saying about kratom as a justification for promoting a ban on kratom in the Czech Republic. And that conference and seminar that was presented heard the reports on the science and the accurate information about kratom's actual content of the alkaloids and the effects they have on people and the psychoactive properties of metrogenine as it relates to people that are finding great benefits from using kratom. And one of the participants on that panel was a representative from the Czech Pirate Party, and it was one of the three coalition government participants. And they were a minor party in that coalition, but their representative told me that she was committed to make sure that kratom was properly regulated in the Czech Republic. And at the end, the Czech Republic governance body, the parliament, determined that in fact they would move forward with the actual regulations around kratom rather than banning it. And I think that was a very powerful change in the direction. And of course, it followed what Thailand had done a couple of years ago and started on their movement. And we know that that other countries are looking at this now in the European Union with a more reasoned view of kratom and its potential benefits for people, and certainly are rejecting this failed policy of bans that has been so aggressively marketed by the Food and Drug Administration. I then had the opportunity to participate in an international conference on kratom in Thailand in August. And it was really incredible to hear not only the presentations that were being made of scientists in Southeast Asia that were recounting the evidence and data that they are collecting, which mirrors largely what we're seeing by the reputable scientists here in the United States about the safety and addiction profile of kratom. And more important, it was amazing to be able to meet with participants in that conference and hear about their recounting of the scientific progress that's being made in Southeast Asia that is moving the needle along this, all of it rejecting this powerful influence and bully pulpit that the FDA has tried to establish. And we're seeing that rapidly eroding. I think that the beginning of that, of course, was the rejection by the Expert Committee on Drug Dependence of the FDA's narrative about kratom and their unanimous decision to determine, as the United States government had determined, in the words of Dr. Zhuo, then the Assistant Secretary for Health in 2018, when he withdrew the application by the FDA for scheduling of kratom under the Controlled Substances Act, where he called it embarrassingly poor evidence and data and a failure to consider the overall public health. The movement against the FDA on the international stage is significant. We know today that here in the United States, they remain committed to do everything that they can to get in the way of kratom being available to consumers. And of course, they are using their significant bully pulpit, both in terms of the voice in the health community through their extensive websites and information dissemination platforms, including social media platforms, to the actual intervention that's happening in states where the FDA is trying to convince state regulatory bodies to intervene with blocking consumers' access to kratom. We're going to talk about what's happening in Florida in just a couple of minutes. But I'm here in Columbus, Ohio for a hearing tomorrow. And interestingly, I walked by the building where the Board of Pharmacy is housed here in Ohio a little earlier this afternoon, and remembered the 300 plus Kratom consumers that showed up and were ready and actually participated in a public hearing to explain why Kratom had helped them, how it had improved the quality of their life, and in many cases saved their lives. And that led to the decision by the Board of Pharmacy to withdraw their petition for the scheduling of Kratom in the state of Ohio, and their deferral to the Ohio legislature to act on Kratom legislation. And of course, tomorrow we will participate in the second of 3 hearings in the Senate Health Committee to review Senate Bill 103, the Ohio Kratom Consumer Protection Act. We've got a star lineup of witnesses. If you haven't yet, you should go back and watch the testimony in Wisconsin a couple of weeks ago. It's available on the Wisconsin legislature's website on the State Affairs Committee. I think it was sort of set the stage for the message that we're promoting, and we actually have strengthened our witness lineup here in Ohio to go forward. I, of course, will be representing the American Kratom Association and the interest of consumers in this issue. And then James Carroll, the former drug czar in the White House, the director of the Office of National Drug Control Policy, will testify. And his testimony in the past has been that he directly participated in the effort to convince then DEA Administrator Udom Dillon to accept the withdrawal letter from the Assistant Secretary for Health, Dr. Giroir, with its blistering rebuke of the FDA. And that, of course, led to ultimately, with the support of the White House, the deferral of the scheduling, what was imminent when, in fact, it was going to take place the next day after August 16th of 2018, when that letter was accepted by the Drug Enforcement Administration, withdrawing the FDA's request for the scheduling of Kratom at the national level. Dr. Kirsten Smith will testify. Dr. Smith formerly was with the National Institute on Drug Abuse and was one of their lead scientists in evaluating Kratom and looking at the science that showed its profile in terms of the safety and addiction profile, which are so critical to maintaining public access to Kratom. Dr. Smith is now with Johns Hopkins University and is leading up their Kratom research efforts. And she is a magnificent spokesperson for the science that actually underpins our efforts to assure that Kratom remains accessible and the reasons why it is a valuable asset for the American public to have access to this plant in helping them, particularly in critical issues like weaning off of opioids and to manage acute and chronic pain, where otherwise the only option they have available to them are obviously highly addictive and potentially deadly products that are FDA approved for the management of acute and chronic pain. John Schintzholzer, who is the president emeritus and founder of the McShin Foundation, which is the largest nonprofit addiction recovery group in the state of Virginia, and what a pioneer he has been in identifying in a community that is driven by 2 things. One, money. Addiction recovery centers have identified Kratom use disorder as this new category of a profit center for them. Not that it has any kind of rationale for establishing Kratom use disorder to be treated with the 3 approved drugs, highly potent chemicals that themselves have a significant addiction profile, being used to wean a person off of a Kratom addiction, which, except for rare instances, would not require any kind of intervention as they have designed and which they're cashing in on. But John Schintzholzer is this rational voice in that community, and he speaks powerfully to why it is a part of the solution and certainly not the problem. Senator Kurt Bramble, the true pioneer and who led the initial effort in order to pass the first Kratom Consumer Protection Act, which has become the benchmark around the states, as we now have 11 states that have passed it, and we're looking forward to Ohio passing it and moving forward in North Carolina as well, which, by the way, North Carolina passed the KCPA last week from the House. It's now been sent over to the Senate, so we're seeing significant success there. We also have a major Kratom business leader whose business is based in Ohio, who will be providing testimony. And then this is one that I hope everyone that is attending tomorrow will take a moment to say thank you to. And if you are just watching online in the stream thing, that you will recognize this witness, who is the mother of a son who a medical examiner in Ohio designated the cause of death as being metrogenate intoxication. This mother courageously stood up and told them they were wrong. And the circumstances around this particular young man's death involved some medical problems that he was having, struggles with some other issues that required him to be on some very powerful medications, all of which were ignored in the evaluation of what the cause of death was. And the basis for the cause of death was made by a representative of the medical examiner's office the night that the body was found. And then this investigator observed that there was a package of Kratom products on the nightstand, right where the body was found. And he told the mother at the time that they were classifying this as a Kratom death. She objected strongly and said that her son had struggled with some addictions and for 5 years had been saved by Kratom. And Kratom certainly could not have killed him. And then she talked about some of the medical issues that her son had reported to her that particular week, some related to COVID and some related to the medications that he had been prescribed by his physicians. When you look at them, they themselves have a very toxic profile and likely could have or would have contributed to this young man's death. The medical investigator finally said, okay, I'm going to let the tox report speak for this, and that tox report will be 2 to 3 months in preparation before it could be received back by the medical examiner's office. But incredibly, early the next morning, the medical examiner himself called the mother and said that he was designating this as a Kratom death. And despite her protest, saying that even your own investigator said that it would take 2 to 3 months to get the tox screen, he said, I'm basing this on the sufficient evidence that I have. Clearly improper by any standard. And this mother is suing the medical examiner on this issue. And interestingly, we just learned as a part of that case that the blood sample that was a part of the autopsy for which there would be good evidence was somehow destroyed by the medical examiner's office, out of protocol, out of procedure, and suddenly was not available for this, which shows you the fundamental problem that we run into when we try to get the truth out, because these family members, all of them collectively, need to know the truth. And the truth isn't being found in a report by a medical examiner who buys into the biased view of the FDA and uses that as the basis for making a determination without doing the proper investigation or conducting the proper autopsy procedures that are necessary in order for that family member to know the truth about what caused the death of that family member, as opposed to the biased interpretation or following the bully pulpit pressure that's being applied by the Food and Drug Administration in order to build a database of what they determine to be Kratom-caused deaths. So this mother is a champion for us, and I hope everyone will recognize that as we go forward. In terms of planning for tomorrow's hearing, this, as I mentioned earlier, is the second of 3 hearings. It is a proponent's hearing, which means that we likely will not, and it would be unusual if there was any opponent testimony. So this is our chance to make this presentation. There's a limited amount of time that's been allocated for this, but we need people to show up and have your presence there, much like we did in the Board of Pharmacy meeting. We've got stickers. Whoops, I'm on the wrong side. These stickers here that we'll hand out, which will allow the committee members to see the strong presence of the Kratom community that are there ready to speak up and to fight for the freedom to purchase Kratom that's properly regulated in Ohio. So we encourage as many of you who can come to participate in this hearing to pack that room tomorrow and make sure that that our voices and our presence is clearly identified by the members of the committee. We know that there are two members of the committee currently who are probably going to follow the Board of Pharmacy line on this. And we're hoping that will prevail with the rest of them, but even move one of them. There's one member that I'm told is probably pretty resolute in his position. But we will meet at 9:15. The hearing starts at 9:30, right outside of the South hearing room. And then we'll distribute these stickers so that you have them. I'll probably need a volunteer to help me to get that done because we'll be gathering some of the witnesses at that point, having discussions, but we'll meet there at 9:15. The South hearing room is just inside or very near to the 3rd Street entrance to the Capitol. And you can ask the security people there and they can guide you to that area so that we can have a brief meeting prior to the hearing. There are a couple of bills ahead of us. One is just the sponsor statement on a bill, and that usually takes about 10 to 15 minutes. The second bill may take 20 to 30 minutes, maybe a little longer, depending on what the complexity of the bill is. And then we will be up for our presentation. So hopefully you can all get there by 9:15, and we'll be prepared to participate in this hearing. So that's where we are. Let me stop at this point and invite anyone who has any questions about the Ohio situation. Then I want to talk about Florida. But for those that are on the call, if you would like to ask a question, you can use the chat room or you can raise your hand and we'll be able to talk about this. And the only question we have up right now is on Florida. But I'm going to get to that in just a second when we have finished the discussion about Ohio. So anyone have any questions about tomorrow and what our plans are and what you can do to help us in actually making this presentation? And Misty is saying the chat's disabled, so I'm not sure how we can handle that, Ryan, if we can.
I'll turn it on in the background. In the interim, if we could just use the Q&A while we get that fixed.
Excellent. So just use the Q&A if you would. So we'll give it another couple of seconds. If anybody wants to ask any questions, they certainly can do that. So we'll come back to it if you have any as we go through. Let me tell you what's going on in Florida. By way of background, the Florida KCPA was passed. There was a compromise at the end of the session as we were trying to negotiate with the Department of Agriculture about what the scope of the regulatory framework would be for the participation by the Department of Agriculture in Florida in regulating kratom. And what the dispute was largely around how much money would be allocated by the state of Florida for that regulatory plan. The Department of Agriculture came in with a number of $20 million. Now, just to give you some perspective on that, in the state of Utah, which has had now 4 years of experience in regulating kratom, the amount of money they asked for the first year in 2019 upon its passage was $172,000. Now, they have not had a need to increase that amount in the 4 years that kratom has been regulated by the Department of Agriculture in Utah. And they just the department issued a report about their experience with kratom over the last 4 years. And they explain why that they've been successful in regulating these products and some of the highlights of what their regulation has been, including that they've not identified any adulterated products on the market. They did identify one kratom product, well, at least a product purporting to be kratom that had no kratom in it when they tested it. And that's obviously consumer fraud, but they didn't see any problem with the kratom products were offered for sale on the marketplace. They did ask that one product, I think maybe one or two products be removed, but there were no dangerous products. The removal was because of lack of compliance with the regulations. So that's the issue that we're dealing with in the state of Florida, where they absolutely were demanding that they get $20 million. And for context, I learned later that the department feels that the Florida legislature has imposed unfunded mandates on their department over the last 5 years. And Kratom became the vehicle that they were going to be able to recapture some of that money. And that's part of their motivation for this. They also misunderstood what their regulatory role was going to be, because the framework for the Kratom Consumer Protection Act did nothing that would impose a huge, extraordinary burden on them in terms of hiring FTEs to do this regulation. When I had the discussion with them, and I explained to them the success in Utah by the Department of Agriculture there, they did modify their position to $10 million. And then the argument for that was that there is a difference in population of about 8 times between the population of Florida and the population of Utah. And that's true. But the number of products that would apply for registrations in the state of Florida would be no different. And if there were, it would be marginal, because there are about 500 compliant Kratom products that have been submitted to the Utah Department of Agriculture that have been approved. And there wouldn't be all that many more, if that many, that would be apply for registration in the state of Florida. And when I made that argument, the department bean counters, those that were trying to collect money, weren't happy with that explanation. And so they said, well, because of the population difference, we probably will have more complaints about Kratom. Well, that would require 2 things. One is that any complaint about Kratom equality and an adverse event gets reported to the FDA. And they, as we all know, are eager to accept those. And they would be the ones conducting any investigations into a Kratom product that was unsafe, that's on the marketplace. And so the only thing that might be left is that the FDA had to hire 1 or 2 people that would then pass on those kinds of complaints. The other would be if there were reports made by consumers about non-compliant products, and that would require there to be an investigation. And there is probably nothing different between Florida and with the number of products that are regulated and what happens in Utah. But after some evaluation, the department then came down and said $2.3 million, which is still extraordinarily high and probably would have, if implemented, because the registration fees have to be spread out over the applicants in order to get that number. So we're not asking taxpayers to do this. It is self-funded through the registration fees. And that registration fee would be a barrier to many of these Kratom products getting on the market, and would have had the effect of reducing the number of Kratom products that would be available to the citizens of Florida that they could choose from, and would be anti-competitive. And the fiscal analyst, that is the person who evaluates legislation and makes a judgment and looks at the data that would support legislation passed, determined that the right number was $760,000. We still think that's a little high, but that's certainly reasonable within a reasonable framework for us to move forward. The Department of Agriculture challenged that, and so we were left with the only regulatory responsibility that the Department of Agriculture has in Florida was to implement the regulations around the sale of products to individuals under the age of 21. That's it. When they did their rule, that is, they published their draft rule, they took a much broader regulatory framework that was never envisioned by the legislation if it had been funded properly and all of the regulatory requirements had been implemented, which they had not been. And so it was a very odd reaction from the Department of Agriculture to take that particular position. What we have learned is that in addition to proposing the rule, which we have contested formally, provisions of that rule that don't make any sense and are not properly framed around the existing legislation, that would happen next year after we agree to some funding mechanism that we could move forward with that. But they jumped the gun. And what it clearly is happening now is that outside of that rulemaking authority, they have inspectors that are going to retail establishments. There are Kratom bars in Florida, which are a very popular social venue where people go to socialize and to have the Kratom experience without becoming intoxicated like they would if they were going to a bar. And those establishments are being visited, and the inspectors are apparently telling these retailers that they are to quarantine their products, that the reason for that is that the FDA has issued an import alert on Kratom products that unless and until the Kratom vendor, retailer, can document that the source of the raw materials that were used in the production of the Kratom product were from domestic sources, they were shut down because of this FDA import alert. That's the first time we've seen a state agency attempting to enforce a regulation that is poorly founded at the federal level and doing the dirty work of the FDA. So we're obviously going to aggressively challenge this. We've already started discussions with the Department of Agriculture. They're denying some of the experiences that have been reported by these retailers, but we're gathering information, and we're actually going to have a war room discussion about Florida at an upcoming the Kratom Summit meeting that will involve our attorneys, that will be held in Denver in conjunction with the Champ Show there. So we're building the strategy and looking at what we're going to have to do in order to intervene with the FDA, I'm sorry, with the Florida Department of Agriculture. So stay tuned on that. We're going to do everything we can to fight back because they're overreaching. They're obviously exceeding their authority, but it's clear that they're doing it in cooperation and in conjunction with the Food and Drug Administration. Separately, we know that there are inspections being conducted by the FDA in the state of Florida and in other locations around the country, but they're targeting Florida, which is why we think this is a concerted effort that they're engaged in. And we've been able to document that the FDA is now, again, pursuing the very same kinds of arguments that they're making through the State Department of Agriculture. This is a serious problem for us. This is a way for the FDA to, again, abuse their regulatory authorities, to act outside of what was permitted by law, because we know that the federal statute that empowers the FDA to issue import alerts is really based on the idea that it would single out an individual specific company that is importing into the United States a contaminated product, and the import alert is designed to stop it for a period of time, and that period of time would allow for that vendor to correct the problem and go through a very specific procedure in order to demonstrate that their products are now safe for entry into the United States. That was the intent of that law. And the FDA is clearly abusing that and expanding its regulatory authority to do one thing, and that is to create a de facto ban on Kratom that they cannot accomplish under the Controlled Substances Act in order to have it banned at the federal level. They have failed now twice in their effort to do it. And the death knell came to them when Dr. Giroir not only told them that they were using embarrassingly poor evidence and data, and they failed to consider the overall public health, he gave them the roadmap of what they needed to do, they, the FDA, in order to submit a new application or petition for scheduling. And in the intervening since 2018, 5 years, they've done none of that. They're not serious about following appropriate scientific protocols. They're interested in prosecuting their bias that has been longstanding at the FDA against all dietary and botanical supplements. And so our fight is clear. We're going to have to re-energize and organize the advocacy base. I know that there are people within the Kratom community that have determined that we've won the battle. They're wrong. If we allow the FDA using their devices unfettered to continue to expand their regulatory authority, they will be successful in removing Kratom from the marketplace here in the United States. There are a group of people that say, oh, well, the AKA is always crying wolf. They're always saying that the sky is falling. There is one reason today why Kratom is not scheduled at the federal level, and that is because of our collective efforts, our organized efforts, and the voice that you have given to the American Kratom Association to fight back. Anyone who thinks differently doesn't understand the reality of the world and the regulatory world that we're living in. It is a fact. And we can't let our guard down. We can't let our own people, because they're fatigued or because they want to carp about us, and there's another segment of the Kratom community, and it's there, that they say we don't need to have any regulations. And there are people who literally espouse the view that, the truth is that Kratom is a benign substance that is not subject to any regulation by the Food and Drug Administration. That's directly contradicted by the U.S. law. It's the Food, Drug, and Cosmetic Act, which empowers the FDA to have regulatory control over all foods. And food is a broad category, by the way. It's not just conventional foods, but it's also dietary ingredients, dietary supplements, botanical supplements, and that they have specific authorities over these substances with respect to new dietary ingredient notifications, which were a part of the grand compromise to allow dietary supplements and botanical supplements to stay on the marketplace in 1994, which provides that if a company wants to make a structure function claim, which is about wellness, general wellness, if they want to use that in their marketing materials in order to actually use that claim to enhance sales, they have to get a new dietary ingredient notification. But we know the conundrum here. It is the FDA that is the judge, jury, and executioner on all new dietary ingredient notifications, and they have rejected all that have been submitted to date by Kratom manufacturers, totaling 7 applications, I think, 6 or 7. The most recent one, which included a human clinical trial demonstrating the safety of Kratom at specific dose levels, and they simply refuse to even consider it. So the FDA is not acting in good faith on these issues, and they cannot be permitted to continue with the authorities that they're abusing moving forward. And that's why we're fighting so hard to get the Federal Kratom Consumer Protection Act refiled and to move forward with the Congress evaluating exactly what's going on. But while we've been doing that, the FDA has been sending an army of people down on Capitol Hill to try to thwart us at every turn. But we're now at the point where that legislation is going to get filed very shortly, and we're going to start the process of fighting back at the federal level, at a regulatory level, with the FDA, exposing their abuses of power as they go forward. And we cannot afford to have a divided community on this issue. We're going to have to set aside some of the internecine war that goes on here, and we're going to have to do our best to move forward. And then I know that there are, of course, this newly formed anti-Kratom groups that argue that their loved ones have been subject to fatalities because of Kratom. We argue that proper regulation would eliminate a lot of the issues that they're concerned about. We also argue that every family that has suffered a loss like that should know the truth. And the truth has to be not with a medical examiner that's shortcutting the way, not using proper autopsy procedures, or making conclusions based on the bias of the FDA rather than on the science. That's the conundrum we're in right now. And we need to do everything we can to assure that those families actually get the truth. And we can't do that as long as the FDA is the one that's running the show when it comes to these kinds of decisions. I can't tell you the number of times that I have heard from public policy officials, from health officials, from law enforcement officials, from other healthcare providers, when they say, when they open the discussion about Kratom, and they say, well, the FDA says this, and then fill in the blanks. The FDA is not an honest broker when it comes to Kratom. They have their own bias. They're prosecuting that bias, and that's why we're fighting back as best we can. So that's the bottom line. I will now open up the questions, and maybe Ryan, if you've been watching these questions that come up, you can repeat them to me, and we can respond to them.
No, thank you, Mac, and you've covered most of them, but there are a few. One back regarding Ohio. For those who live outside of Ohio but travel or have family members in Ohio, when should we communicate with the board members, now, tomorrow, or after the hearing?
Well, ideally, we get a good showing that actually attend the hearing. We pack that hearing room, so that's great. There will be opportunities to communicate with committee members following the hearing, and we'll certainly provide the platform for you to do that. And so we'll make sure that you have that information and the way that you can actually make your comments and report to the members of the committee your own experience with Kratom. because goodness knows that the anti-kratom people are going to be doing that. And that's their right. They have a First Amendment right. They're not entitled to lie about it. And that's why we've amassed this array of witnesses that I think speak directly to the truth about kratom, and rather than just following the FDA's nonsense that they espouse, which is by any definition misinformation and disinformation. They are lying about kratom. And they know it. There are people that have admitted it at the FDA, but they can't even fathom why the commissioner's office is doing what they're doing. But that's the reality of it, and we have to fight back.
Thank you. And back to Florida. I'm a reporter. This is from Tom Lemons. I'm a reporter in Hernando County, Florida. I also support the use of kratom. You say they are using a federal law to prevent deliveries from outside the U.S. Is that law currently being enforced? What if a company in another state delivers that product to Florida, even if the product came from outside the US? And how does a retailer get around that regulation?
So Tom, first, I would welcome a call from you where we can talk about this in some depth. But let me tell you the bottom line here. The regulatory authority granted by the federal law to the FDA was designed, as I described earlier, to interdict contaminated substances. What the FDA has done is they've determined that all kratom raw materials, without respect to whatever it's used for, is adulterated per se because it does not have a current registration as a new dietary ingredient. That's what they say. Now, as I mentioned earlier, they are the judge, jury, and executioner on that. They get to approve all NDINs, and they refuse to do so, even when there is compelling scientific evidence. Now, what the FDA is saying is that under that law, they get to go in and stop any product that was manufactured from raw materials that were sourced outside of the United States. Now, we think that is a gross abuse of the law. We've had legal opinions that have been generated because here's the bottom line. An importer of kratom, a broker who receives kratom shipments from overseas, doesn't have any specific intent for it to be marketed in any way. And it is only when a finished product is manufactured that then the manufacturer has to decide whether they want to use a structure function claim, in which case they would be subject appropriately to an intervention by the FDA, not as an import alert, but rather for violating the manufacturer or the labeling requirements under DSHEA, the Dietary Supplement Health and Education Act, and they're making an impermissible health claim. In this case, what's called a structure function claim. That's the appropriate mechanism to catch a product that is being marketed that way. And similarly, we completely agree that any product that is marketed with an illegal therapeutic claim, that's not the raw material, because there is no importer the FDA can point to that's saying this kratom is used for getting off of opioids. The importer doesn't say that. There's no bill of lading that says that. There's no marketing material associated with the kratom raw materials coming into the United States that imputes any therapeutic claim to it. It is only when a finished good is manufactured that that requirement is in place. And we completely agree that those therapeutic claims are improper. And we've submitted over the last 3 years nearly 80 complaints to the FDA identifying specifically violative marketing claims being made by kratom manufacturers whose products should be removed from the marketplace and prosecuted by the FDA to do so, and not a single prosecution during that 3 years. So it tells you that they're not serious about this. This is just their tool that they're using to try to stop the sale of kratom products, and they're abusing their authorities to do so. So I would welcome the opportunity to talk to you about this in more detail and share with you some of the legal opinions that we have about this. But the FDA is simply doing it wrong, and that's what we've got to correct as we go forward.
Great, thank you. And a question about Indiana, if you have any updates.
Indiana, the KCPA, which repealed the existing ban, passed 53-40 in the House and was sent to the Senate. The Senate Health Committee asked that there be an interim committee study done, and that's ongoing right now. And we expect to take up this issue in January on the Senate side to resolve any of the questions. But they asked for, the Senate committee asked for a report from the health department there. And we're, of course, providing information that would make sure that there's accurate information available to the committee members to make their own evaluation of kratom, much like we did on the House side.
Great. And a question here, what determines the timetable for introducing the federal KCPA before Congress? Now would seem an excellent time with the FDA acting so egregiously.
Dead right. And we expect that that federal bill will be filed here in the next couple of weeks. We've had a little bit of a challenge because the FDA has been so aggressive in trying to counter the provisions, and we've had to deal with educating staffers and members of Congress. But that's gone great because once they see it, they understand it. We have passionate advocates who will file the bill. The other challenge was we had a little bit of a changeover in staff in one of the sponsors on the Senate side that required the new staffer to be re-educated about kratom. And I think we're now at a sufficient comfort level that you'll see that that bill will be filed and it will start this discussion up on Capitol Hill.
Well, thank you, Mac. There's a couple other questions here, but I believe you've answered them through your review this evening. We'll leave the chat open for a couple more minutes here.
So I see one that is an interesting question. Would kratom being shipped straight to the consumer from out of state be affected by the FDA's efforts? This is a big problem, and here's why. I know, having visited Indonesia multiple times, that there are farmers who are shipping raw materials directly to consumers in the United States and to small businesses. Now, this is a difficult issue because most of those farmers are trying to do the right thing, but none of those farmers have the capability of actually processing that kratom in a way that would assure that it's not contaminated. So and I see this all the time, there are reports from consumers in the United States who are buying kratom from a trusted farmer. Well, there's no reason to trust a farmer over there. They're not trying to do anything wrong, but they've just fallen into this procedure where they can get away with it. And that's the issue. That kratom is not being tested. It's not being tested for contaminants. And even the large farming operations, which are getting better at it, aren't very good at matching the requirements for a properly evaluated and tested product. And so there's that issue. And then I can tell you as a fact that the people just like they are here in the United States, people are very creative at putting together very official looking documents that are not supported by accurate findings. There also is a serious problem with shipping kratom from the farm areas into the processing centers, and that requires that there be rigorous standards imposed, which are very expensive. And the good news is that I visited a couple of months ago at the end of July, I visited two major processing centers in Indonesia that were fabulous. They're actually taking care of eliminating the contaminants. But anyone who's buying kratom directly from a farmer and over time has just gotten to trust them is playing Russian roulette. Not only with your own life, by the way, but also for the credibility of our industry, because we know that under the Food, Drug, and Cosmetic Act, every gram of kratom that comes into the United States, whether the vendors or the consumers like it or not, is subject to strict regulations to assure the quality and the lack of contaminants in the food products that are being brought into the United States. And we can't escape that. And those that want to say, well, hey, we're libertarians, we have the right to do anything we want. No, you do not. And I can't stress that enough, because in the end, it will bite us hard if we allow that to continue. So in my discussions and in AKA's team's discussions with the Indonesian government, we have strongly advocated for there to be standards that are imposed by the Indonesian government that match what the FDA requires, so that when the kratom raw materials leave Indonesia, all of it is tested to make sure that it meets the purity standards and lack of contaminants that are required by the Food and Drug Administration. That doesn't mean it's zero contaminants. It means that they match what the FDA requires so that the safe levels are achieved. And we can do that if we work together. But those in the kratom community who insist that they're the libertarians of the world and criticize those of us who are trying to bring sanity to this process and to protect the long-term availability of kratom to consumers who benefit from its use here in the United States have simply got to get off this kick that, hey, we have the freedom to do anything we want. You do not. And that's the truth of the matter. That's a little tough love, but it's the way it is. And we just have to live with that. And I can tell you that for every Kratom consumer that wants to say, hey, I trust my farmer and I get it, and I'm not going to worry about you people, the same arguments have been made in the dietary supplement industry generally, where raw materials are imported without the controls that are needed in order to ensure their purity and their safety. And the dietary supplement industry has suffered because of it. We can't afford, with the focus that the FDA has on the Kratom industry, to allow that to happen with us. And so I think our progress over the last 4 years cannot and should not be undermined by these free thinkers. And by the way, I know no one intends to do anything wrong, but the reality is that the supply chain of Kratom raw materials can have contaminants introduced that are unknown, but yet deadly. And we just can't afford that mistake to be made.
Great, thank you. And do you feel like this Florida mess is brought on by a local Florida Kratom farmer?
No. I've seen that on social media. The great news is that in the state of Florida, Kratom in certain areas can be grown, and it is a potential replacement crop for the citrus plants that died down there because of a canker. And in the preliminary investigations that have been made, they found that Kratom grows well. It's looking promising that they will be able to grow in a way that matches the output of the alkaloids so that they can have quality products being manufactured from them. We think that's wonderful. Same is true in Hawaii. There is a fairly substantial Kratom farm in Hawaii that is looking to dramatically expand its capacity. These are great things. It provides competition for pricing, which will benefit consumers. It helps us avoid some of the overregulation by the FDA. But let's face the reality. Currently, we rely upon foreign sources for Kratom raw materials to supply a marketplace that's growing dramatically. I mean, we're at 15 million plus today, and that's growing all of the time. And so we just can't stick our heads in the sand and think, oh, well, you know, there are bad actors here. I don't believe, to address the question specifically, that any individual is responsible for what's happening in Florida, other than the staff that sits in the policy office at the FDA under Commissioner Califf, who are responsible for these bad acts. That's what's happening here, and it's not new to us. You have an FDA that went and literally got the Department of Justice to file a lawsuit against the Kratom manufacturer, again on the same argument that this is Kratom raw materials that are per se adulterated because they're under the import alert because they don't have an NDIN. And this was an attack on a company that has what I would consider to be a relatively benign product with Kratom raw powder in it and some liquid, and that's it. And yet the FDA is targeting them. It is unexplainable why the FDA has this bias, other than we look at history. And if you closed your eyes and we could be transported back to 1993, the FDA was saying that vitamins and dietary supplements were killing people. And that's why the FDA wanted to put every one of those products through the new drug application process, knowing that a natural product comprised of natural ingredients wouldn't be able to sustain that evaluation because of the money involved. And that was their game. They were saying, oh, people are dying from them, and they're saying that they're dangerous products. Now come back to today, they're doing the same thing against Kratom. But what did Congress do in 1994? They didn't buy the nonsense of the FDA. They recognized that there were impassioned people that were exercising their freedom to use products that were helping with their health and well-being. And so they passed the Dietary Supplement Health and Education Act. And that's what started us on the protected journey, where today the dietary supplement industry is nearly $100 billion industry. 80% of American families use them. The consumers have spoken loud and clear. And yet, if the FDA had their druthers about this, they would ban vitamins and dietary supplements tomorrow. But they can't, because Congress stood in their way. We want Congress to get in their way again with respect to Kratom.
Excellent. And since Florida passed the KCPA, what do you recommend kava bars do in this situation?
Fight. There's no basis for the actions by the Department of Agriculture. Join us in this fight. We're going to have lawyers working on this. We'll have a legal strategy straight away. We need to fight this battle because if we allow them to win a regulatory assault on kratom in Florida, then it will spread like wildfire. Fight with us because that's the solution.
Thank you, Mac. Just an update on Michigan.
So Michigan is next year, we're going to be back at it, as we will be in a number of states. We've already plowed the ground. We're getting great support in Michigan. And I think you're going to see progress there in the upcoming year.
Great. And it looks to be our final question from Heidi. How do you feel about the chances of Wisconsin passing the bill this year, considering the opposition from medical associations and sheriffs?
So I am very optimistic that we are going to get passage of this bill. And here's a couple of reasons why. The medical association there has got their heads in the sand. The lobbyist for the medical association stood before the State Affairs Committee and without question lied about it. For example, and we've objected strongly to this and corrected the record. He tried to make the case that we were misstating, that I misstated in my testimony, the position of the American Medical Association. Now, he specifically took issue with statements that I had made in my testimony, but I was reading directly from the resolution that was passed by the AMA House of Delegates. And he was claiming that we were circulating to the members of the committee a false document. All the document was the resolution passed by the American Medical Association House of Delegates, and it took the signature line of the lawyer that had sent it to Senator Kirk Bramble pursuant to a request, and it put it on top of the paper so that if anyone wanted to call that guy, it had his information on it, and then it just had the actual language from the email of that attorney put into a document. That's all it was, and they called it a lie. Now, we, of course, called them out on that, and I think that the committee members see clearly that the lobbyist for the medical society in Wisconsin was not telling the truth about things. And I think that similarly, we've seen that the testimony that was provided by the medical society with respect to addiction liability of kratom was distorted. It was extrapolated out of thin air. And we have the advantage of an evaluation by scientists and by the Controlled Substances Board, where they admitted that it didn't meet the criteria. And they did pass a second resolution saying, but we don't think that kratom should be made available just without any kind of restrictions. Well, we don't either. We want it to be regulated appropriately. And so I think that that we have an excellent chance of being able to get through. Our bigger problem there is not the medical society, but rather law enforcement. And we just the core of the testimony of the law enforcement people were that they're having significant problems with kratom. The sponsor of the bill, Representative Murphy, asked the crime lab in Wisconsin, and we just got the report back from the crime lab where they reported that the test, and they test for every one of these incidents reported by law enforcement, which includes operating while intoxicated, they call them OWIs, and any crime lab associated with the drug incident. And they reported back that over the last 4 or 5 years, of tens of thousands of incidents, they found less than 1% involve kratom, none that involve kratom alone, always with polydrug use, which is not in any way surprising to us. And it directly contradicted the conclusions of the Sheriff's Association member. He overstated this case. And we think science and facts should rule here. And if that's the case, we're going to be very successful in Wisconsin, following Vermont in rescinding the ban on kratom that was done there. So I think we're looking great in Wisconsin. I'm very optimistic. I had a discussion with the Speaker of the House in Wisconsin last week at a legislative leaders conference, and he is optimistic as well that this is going to get passed out of the House and go to the Senate. And he thinks that the passage by the House will obviously provide the basis for the Senate to follow suit.
A couple more questions.
Let me just, sorry, Ryan, let me just say that the testimony we provided, if you'll go and watch it, listen to the kratom consumers, listen to Heidi's testimony, listen to these messages. These are heartfelt, real life experiences that people have. It's not a clinical evaluation. It's not some self-empowered lobbyist from the Wisconsin Medical Society saying, oh, kratom is bad. These are people that have benefited from it. And I'm grateful for those voices because they tip the scale back to reality from this nonsense that's being spewed by our critics.
It's great. And update on California.
So as I've said before, California is a problem just because of the size of the state and the resources that are needed in order to, frankly, to hire lobbyists and to start this battle. But we've overcome, at least taken the first major step on that. We have lobbyists retained, and I think we're going to be moving forward. We're also working in the city of San Diego to get that ban repealed. We have a lobbyist down there that's working on that. So I think that that we started that journey, and we're going to see how it fleshes out once we get sponsors online to determine what our chances there will be. But I think that California is a tough state for us, even because you look at their drug policies, they're enlightened in many cases, and there's no reason for there to be any resistance, we think, to the KCPA, but we're going to continue to work on that. We're seeing this in other states too. We went to to Arkansas, and we made our appeal directly to Arkansas, as we did in Vermont, with the same arguments about the lack of credibility of the science that was used by the FDA that was the reason that Arkansas initiated their ban. We got turned down by the Department of Health, but we had a sponsor who himself is a pharmacist in Arkansas who submitted the bill for what they call their interim study committee. Arkansas meets every 2 years. So in January, you're going to see a committee evaluation. I would encourage everyone to go and read that bill. It is fantastic. The findings that they cite are fantastic. They're aligned with the values and the policies that we have at the American Kratom Association and that our advocates support. And so I think that we'll be successful in Arkansas here and when they reconvene in 2025.
Thank you, Mac. And it looks like the last two questions here, an update on Arkansas and an update on Louisiana.
I just covered Arkansas. Louisiana, very tough. And if there's a lesson that we can take from Louisiana, is that you see the power of disinformation by law enforcement officials that are dictating these bans. We had an unfortunate situation in Zachary, Louisiana, where a city banned kratom, and it's right outside of Baton Rouge. The city council wasn't interested in hearing our viewpoint. Ryan himself went down there and spoke on behalf of the kratom community. We had great advocates that stood up and spoke, but it was clear that there was zero interest by that board or by that city council. But I can tell you that it exposed one thing that is a tremendous weakness within our community, and that is the personal, and I would characterize vicious attacks and threats that were issued against some members of the city council. And I don't disagree that the mayor pro tem was herself offensive in the way that she treated advocates of kratom on her social media post. But I can tell you there is never an excuse, in my opinion, for anyone to make a physical threat against an elected official. And that prompted an investigation by the FBI, and I suspect it's not going to go well for the individual that made the threat against the life of that city councilwoman. We should win on the merit of the arguments. They're not always successful because in the way you get these influential local sheriffs who are treated like gods, but that doesn't justify our frustration being evidenced in a way that's counterproductive to us. We'll take the losses where we are, but build a case about the quality of our arguments and the civility that we bring to it as best we can. It's hard sometimes. It's very hard. And I know, for example, that we've sat in meetings, in hearings, and we've heard the testimony of families who say that their loved ones were lost because of kratom. Now, we know that that's not true, but in one recent example of a state legislative hearing, one of the law enforcement people came up to me after this impassioned testimony by a mother who said her son was lost to kratom. He said, she's not telling the truth. I've seen the autopsy report, and that kid had all kind of drugs in his system, and it hardly could have been attributed to kratom. But that's what we fight against, because, there's no way to convince someone who is in that situation where they've had a tragedy in their lives, where they want to find, obviously a boogeyman. And unfortunately, another antagonist to that system are the advertisements being issued by trial attorneys trying to build a class action suit, which has one objective, and that is to pick the pocket of some kratom vendor. That's unfortunate, because they're empowered by the FDA's disinformation about kratom. They come in and they make this argument that if a family member passed away and they took kratom, or if they watched an advertisement about kratom, or if they thought about kratom, or they drove by a kratom sign, then they can join the class. And that's sad, because it requires the cooperation of these trial attorneys. And here's something you will never hear a trial attorney say: that the FDA is responsible for their failure to regulate the marketplace, because unquestionably, in the state of Florida, the judgment that was awarded against a kratom vendor that marketed their product as a super potent, powerful extract product of kratom known as space dust, that individual didn't even show up to defend against the case in court. But that's a product that never should have been allowed on the marketplace, ever, because it was a plastic pouch with a Sharpie scrawled space dust with no directions for use. I don't know what would convince a person to buy that kratom, other than what I talked about earlier. Well, it's cheap and we can get it. It needs to be tested for its purity, for its safety. And certainly the marketing of that product raises serious questions about what exactly was in that product. But we don't even know today whether that's what killed that person. But what we do know is that the trial attorneys aren't saying, oh, well, the FDA should have removed that product from the marketplace, we're suing them too. They don't. They're in an unholy alliance with the FDA, relying upon the failure of the FDA to regulate kratom products to be able to generate these kinds of lawsuits that are not serving the public that they're claiming to protect. And they're certainly not going after the proper reason why these bad products, to the extent they are bad, because no one's really made a proper evaluation of that, they should be going after the FDA for their failure to regulate, but they're not going to do that because there's no money there. And these trial attorneys are all about the money. Now, that's why we advocate for good regulations and good common sense kinds of experiences of kratom consumers, which require good instructions on labeling, so that you know what the safe amount of kratom that you should consume in the product that you've purchased. So we're going to continue to fight that battle. We're going to do everything that we can. And this is a battle that we jointly share. It's not just the policy argument, as I referenced earlier. It's about your voices, about consumers that stand up and tell these public policy officials your experience with it. And it really disputes the claims that are being made by these people who have a self-interest in doing so. And I understand it. If you lost a family member and you somehow were led to believe by some unscrupulous trial attorney that you could cash in on it, of course they're going to do that. But the truth should prevail. And it can't be because some medical examiner just decided to follow the FDA's advice, not good science, and blame kratom for some death because kratom was detected in the bloodstream. That has nothing to do whether kratom caused death. There is no known level of toxicity to kratom that would cause a death on its own. It's only if there are poly drug use and if there's an underlying health condition or unknown substances not detected in the initial screen that was done for the tox screen of that decedent that really need to be evaluated. So we're going to continue to fight that battle. We're going to do it shoulder to shoulder. And that's why I think tomorrow is a good example where we'll be able to stand up and tell our story and convince legislators that this is the right public policy approach.
That's great, Mac. Thank you. And I'm not seeing any other questions that we haven't answered. Did you have any closing comments you'd like to make?
No, I'm looking forward to seeing people at 9:15 tomorrow for those in Ohio that are able to come and join us. We'll hand out these stickers that'll show these legislators that we're a strong voice. We need that. We need you to come and participate in this hearing. We'd love to meet you personally, and we're looking forward to that opportunity.
Well, thank you, Mac, and thank you all so much for joining us this evening. We will be in touch in the next couple of weeks with the latest updates, and we'll continue to track